Chess grandmaster Hans Niemann has sued Magnus Carlsen, Play Magnus, Chess.com, Danny Reich, Hikaru Nakamura for hundreds of millions of dollars, alleging slander, libel, antitrust, tortious interference with contract and business expectancies, and civil conspiracy. In today's video, I'm going to be going over Hans's lawsuit and telling you whether or not the lawsuit speaks for itself or if it's just a bunch of BS. Now, because there are a lot of moving parts in this video, I made this neat little diagram. Up top, we have all the defendants. Down below, we have all of the claims and the important relevant issues that I think are going to be brought up in this case. Now, this was not a mistake that this graph exists. I tried making this video without this graph, and it was a terrible video. Ugh. Okay, so before we get into the merits of the lawsuit, I'm going to give a very brief recap of what has happened thus far that has led up to said lawsuit. So here's an article by Indy 100 giving us a timeline of what has happened. So on September 4th, Hans Niemann beat Magnus Carlsen in a St. Louis chess tournament. For anybody who doesn't know, Magnus Carlsen is the undisputed best chess player in the world. He is the highest ranked chess player ever in terms of ELO. He has been the world champion for the past decade. So Hans beating Magnus was certainly a surprise. Hans was clearly an underdog. As you can see here, this was the first time that Magnus had lost in 53 games to Hans Niemann. But to Hans's credit, he is a top 50 chess player in the world. He is no slouch by any means. The day after Hans beat Magnus, Magnus withdrew from the St. Louis chess tournament. We didn't necessarily know what was happening at the time. However, as soon as September 6th, rumors begin to spread online. What rumors, you might ask? Well, the most prevailing rumor was that Hans Niemann used a vibrating anal bead that was inserted in the appropriate place that gave him signals on which chess move to make that helped him beat Magnus Carlsen. This rumor took the internet by storm, even reaching Elon Musk. On September 7th, Hans Niemann claims that he never cheated in this video. On September 19th, Hans and Magnus play again. However, Magnus resigns after only one move. Let's watch the entire chess game live.
And what? No.
What happened? What?
No.
That was the entire match. Magnus resigned. Then on
September 26th,
Carlsen released this statement. Then on October 4th, Chess.com released the Hans Niemann report. It is a 72-page document in which they basically conclude that they believe that Hans Niemann cheated a whole bunch of times while playing online. However, there's no evidence to support him cheating over the board. Then on October 5th, while playing in the U.S. Championships, Hans Niemann gets subjected to a full-body scan while he is entering the competitive arena.
And it's like, come on, come on.
As you can see, the rumors are really getting around because they're checking.
I said what in the butt. I said what in the butt.
So that's pretty much where we're at. One more important factor, which I'm going to include and discuss more in depth later on, is that Magnus Carlsen has pretty much come out and said that he is unwilling to play in any events that Hans is in. So basically at this point, chess organizers have to pick between Magnus Carlsen, probably the greatest chess player of all time, or Hans Niemann. Okay, so let's start making our way through this lawsuit. As you can see, it is filed in the Eastern District of Missouri. Why is it filed in the Eastern District of Missouri? That is where the original chess tournament took place. That is where the over-the-board game between Magnus Carlsen and Hans Niemann took place in St. Louis, which is coincidentally in the Eastern District of Missouri. So the very first issue that I thought of when I read the lawsuit was, does this court even have jurisdiction to hear this claim? Now, contrary to popular belief, in the United States, you can't just sue anyone, anywhere, for anything. The court must have jurisdiction over the claim. Now, generally, there are two types of jurisdiction: personal jurisdiction and subject matter jurisdiction. And you need both types of jurisdiction in order for the court to be able to hear a claim. Now, I apologize in advance if I'm triggering any law students out there. I've just pulled a very basic civil procedure jurisdiction flowchart from the internet. As you can see here, there are two types of jurisdiction: personal jurisdiction and subject matter jurisdiction. As I just said, you need both. So first, let's talk about personal jurisdiction. Okay, and I promise I'm going to make jurisdiction as easy as possible. I'm going to skip over a lot of this stuff because it's unnecessary. So let's talk about personal jurisdiction really quick.
Are you sure about that?
Here's the very high level version of personal jurisdiction. You want to know, is the defendant domiciled in the state? Domiciled is basically just another word for living in the state. It's actually not technically correct, but for the purposes of this video, are they domiciled in the state? Do they live in the state? And then if that answer is no, do they have sufficient minimum context in the state where it is equitable, where it doesn't offend the notions of fair play and substantial justice if you're litigating in that state? Okay, let me give you an example of lack of personal jurisdiction. Let's just say I'm driving my car in Texas and I suddenly get hit from behind by Hikaru Nakamura, who's in Texas for a chess tournament. My response to this is I go to Hawaii and I sue Hikaru in Hawaii. Now, when Hikaru gets the lawsuit, he goes, wow, I've never even been to Hawaii in my life. How can I be sued here? Well, if we just apply the basic personal jurisdiction analysis, he doesn't live in Hawaii. He doesn't have any minimum contact with Hawaii because in this hypothetical, he's never been to Hawaii in his life. And certainly it would offend the notions of fair play for him to have to defend a lawsuit in Hawaii. It'd probably cost him a whole lot more money because Hawaii is so far away. He'd probably have to travel there a whole bunch. He'd probably miss out on work because he had to travel so much. It would be unequitable for the Hawaii court to hear this lawsuit. There is no personal jurisdiction in this case. So if I filed this case in Hawaii, it would be thrown out for lack of personal jurisdiction. Now, I used Hikaru as the subject in my example because I think it's similar here. Here, the chess tournament happened in St. Louis, Missouri. Hikaru wasn't at the chess tournament. He has been to St. Louis before in the past, but he certainly doesn't have minimum contacts. He doesn't frequent himself going to St. Louis other than the occasional trip. Additionally, all of the alleged actions that Hikaru took that were potentially damaging, such as the alleged slander, the alleged libel, the alleged conspiracy, all that kind of stuff happened from the comfort of Hikaru's home because he's a streamer, which is in Florida. So to me, just off of very cursory analysis, I don't think the court would have personal jurisdiction over Hikaru. So as you can see here, I filled in potentially no personal jurisdiction for Hikaru. And if there's no personal jurisdiction, well, then Hikaru will be completely thrown out. The analysis for all these other claims is irrelevant because if the court doesn't have personal jurisdiction to hear the matter, well, it doesn't matter. So now let's move on to talk about the personal jurisdiction of the other parties. Okay, so now let's go back to my car example. This time I'm driving my car, still in Texas, and I get hit by Magnus Carlsen, who's here for a chess tournament. And then after getting hit, let's just say I sue Magnus in Texas. Well, when Magnus gets this lawsuit, he might say, hey, there's no personal jurisdiction here because I don't live in Texas. Well, if we go to our handy dandy personal jurisdiction flowchart that I just Googled online, we can go and work through this analysis. So is D domiciled in the forum state? That answer is no. At least some of the defendant's contacts with the forum state voluntarily, yes, because Magnus Carlsen was in Texas for the tournament voluntarily when he hit me. Then, does the cause of action arise or relate to D's contact with the forum state? Yes, because in the example we were talking about, Magnus Carlsen hit me with a car while he was in Texas. This is going to be the biggest issue with determining the Magnus Carlsen personal jurisdiction. So ultimately, it's going to be up to the court to decide whether or not they have jurisdiction over this claim, because when did the alleged defamation or these claims begin? Was it when Magnus withdrew from the tournament, or was it later on when he wasn't in Missouri when he was releasing these statements. Because certainly I think you could make a good faith argument that Magnus withdrawing from the tournament had nothing to do with what happened after. Had he just withdrawn and not said anything, nobody would have just batted an eye. They would have just forgot about it the next time he showed up to a tournament. He could have just said he was sick or left or whatever personal reasons. But on the other hand, a judge might say that this was the first domino. This instance where Magnus withdrew because he felt Hans was cheating was the domino that led to all of this. Therefore, there's a common nucleus of events that all stem from this jurisdiction. And this is why lawyers can't give any definitive answers, because that answer might change depending on who your judge is. You could file the same case in two separate courts. One judge might say there's jurisdiction. One judge might say there isn't jurisdiction. So based on what I've seen, because it is a toss-up, I'm going to give deference to Hans, and I'm going to say there's potentially personal jurisdiction here. Okay, next let's talk about Play Magnus and Chess.com. Both of these are LLCs. Play Magnus is a Norwegian company. Chess.com is formed in Nevada and has headquarters in California, I believe. But what's important about this is both of these do not have any sort of headquarters in Missouri. However, when you have a mega online corporation or just a mega corporation in general, there's something called minimum contacts. Minimum contacts means that if you basically have a product that is in the stream of commerce and it is continually in the stream of commerce and you continually get business from said state, it is foreseeable that you could potentially be sued in said state. Going back to the car accident example, let's just say I'm driving my car in Texas. Magnus Carlsen is driving a Ford Camry? What's a Ford? He's driving a Ford F-150 because he's in Texas. He's driving a Ford F-150 and the brakes don't work because Ford did a terrible job and I get slammed. I actually decide to sue Ford for making a defective automobile. But Ford is an incorporated Delaware entity, I think, and their headquarters are in Michigan. They're going to say, hey, we're not domiciled in Texas. You can't sue us here. Well, Ford just has such a huge volume and they do so much business in the state and they have so many operations existing in the state. You can definitely make an argument that it does not offend the notions of fair play for Ford to have to defend a lawsuit in Texas, just given the amount of contacts they have in the state. So here, what the court is going to want to know is how much business does Play Magnus and Chess.com do in Missouri? Do they have one active user or do they have tens of thousands of active users? And if they have tens of thousands of active users, how much money are they making? How much time are they investing? Do they have a local office? If they don't have a local office, do they do any sort of events? How often do they go there? Things like this. They're trying to determine if they have substantial minimum contacts to basically justify a lawsuit in the state. But ultimately, Play Magnus and Chess.com are large entities. I would anticipate that they have a number of users inside of the state of Missouri, specifically the Eastern District of Missouri. I don't think it's out of the question for a court to find personal jurisdiction in this particular case. Now, I actually didn't know who Danny Reich was before this lawsuit. I had to look it up. He's the chief chess officer of chess.com, and it says he's a person who's domiciled in Utah. Now, because he's domiciled in Utah and he wasn't there for the tournament, I think it's kind of the same analysis for Hikaru, so I put potentially no personal jurisdiction if he did not avail himself to Utah. But this is just his personal capacity. So I'm going to say no personal jurisdiction, but maybe JX because of his involvement in chess.com. And I only put this caveat here and not under Hikaru because I know Hans sued Hikaru for his involvement with chess.com, but I think these are two completely separate things. Hikaru is just a streamer, in my opinion. He is talent. He is not on the back end of chess.com. Danny Reich is an executive of chess.com. So I think there's a big difference between the two. So this is my analysis on just personal jurisdiction. At this point in the video, you're probably thinking, thank God we are finally done with the jurisdiction analysis. Well, you're wrong. But I'll try to make the second issue quick. So like I said, there's two types of jurisdiction: personal jurisdiction and subject matter jurisdiction. So now let's talk about SMJ. There's two types: state and federal. Let's mostly just focus on the federal here. There are three types of the federal: subject matter jurisdiction, federal question diversity, supplemental jurisdiction. Even though all three of these kind of work together, let's just go straight to the source. Hans Niemann, his lawsuit says that they have jurisdiction because this claim arises out of federal law, namely 15 U.S.C. 1. Additionally, there's supplemental jurisdiction over Niemann's state claims as well. So for any of you legal scholars out there, any of you legal eagles, you might say, you might be thinking, hey, what happens in a case where you have 4 claims? Let's just say 2 of them are federal law and 2 of them are state law, but they all come out of the same operative facts, the same nucleus of operative facts. Well, it would be unduly burdensome for you to have to sue in multiple different courts at the same time. So it would just totally suck even more to have multiple lawsuits pending, basically. So there's this concept of supplemental jurisdiction where if a court has jurisdiction over a particular claim, you might be able to bring in the other claims as well. So here's the very brief flowchart of supplemental jurisdiction. So basically, applying the subject matter jurisdiction here, Hans is suing for hundreds of millions of dollars. There is diversity because everybody's from a different area. Some of the claims are federal claims, some of them are state claims. So he alleges they all arrive from the same common nucleus. Therefore, the court should grant supplemental jurisdiction. And as you can see here on my board, I said probably subject matter jurisdiction for all of them. However, it's important to note that you need both personal and subject matter jurisdiction. So here for Hikaru, it doesn't matter if there's subject matter jurisdiction if there's no personal jurisdiction. Oh my God, I'm sick of tired of talking about jurisdiction.
It's been 84 years.
Okay, the next issue that we need to discuss is public figure. Is Hans Niemann a public figure? Why is this important? Well, under U.S. law, it is extremely difficult for public figures to prevail in defamation suits. Essentially, if you are a public figure, the only way you can prevail in a defamation suit is if you prove the defendant acted with malice. What does that mean? That means that the defendant knew the statements they were making were false, yet decided to make them anyway. Whereas if you're not a public figure, you don't need to prove that the defendant knew that the statement was false and made it anyway, solely that they made a defamatory statement. And that's a big difference. So if you're someone like me, you had never heard about Hans Niemann before. So your initial thought is there's no way Hans is going to be held as a public figure, which is probably better for his case. Well, the courts have long found that there is something called a limited purpose public figure. What is a limited purpose public figure? That's exactly what it sounds like. You might be a limited purpose public figure if you are a public figure in your particular niche. Here, Hans is a top 50 chess player in the world. So even though someone like me, who's a casual observer of chess, might not know him, if you are in the community, if you live and breathe chess, you know who Hans is because he's a top 50 player in the world. And as you can see here from this article that I pulled off of Google, here are the factors when determining whether somebody is a limited purpose public figure. The plaintiff has access to channels of effective communication, which pretty much everybody does with the internet now. Plaintiff voluntarily assumed the role of a special prominence in public controversy. He is literally the controversy, so yes. Plaintiff sought to influence the resolution or outcome of the controversy. Yes, because he wants to clear his name. Controversy existed prior to the publication of the defamatory statement. Yes, the alleged cheating. 5, the plaintiff retained public figure status at the time of the alleged defamation. So, yes, I mean, I would argue before this incident happened, Hans was a top 50 player. Therefore, he is probably a limited purpose public figure. Now, this is why the analysis about whether or not Hans is a public figure is so important. So, in my opinion, I think he's going to need to prove malice in order to prevail on this claim, meaning knowing that the statements were false, yet making them anyway. This is extremely hard to prove. I cannot stress this enough. Extremely hard to prove. And that's because of everybody's favorite word when discussing defamation, and that is opinion. Everybody has the right to an opinion. However, just because you have the right to an opinion doesn't mean you're excused if that opinion is defamatory. Now, a lot of people in the comments will probably be saying, well, Hans admitted to cheating in the past. Well, this video isn't about the past. Also, Magnus and chess.com have never come out and said he's a cheater. They've said they believe he is cheating or he is likely cheating. So if that's the case, this seems like an open and shut case. This should just be kicked out because there was no defamation. Well, it's not as easy as that. The law allows for something called defamation by implication. And to explain it, here's my friend Kurt from Uncivil Law.
The lawsuit from Hans Niemann against Magnus Carlsen principally revolves around defamation. As we discussed in the Johnny Depp Amber Heard case, defamation is a false statement of fact, but those facts don't need to be expressly conveyed. As with the Johnny Depp matter, they can be provided for by implication. So if you have a statement that looks like opinion, but is understood to actually convey the facts, then the facts themselves can be understood to be conveyed, even if it's not expressly on the page. So here, Magnus Carlsen makes statements that could be understood as opinion. For example, saying, I believe that Niemann has cheated more and more regularly than he's publicly admitted. While that might be viewed as a statement of opinion on its own merits, Magnus Carlsen also expressly says, there is more I'd like to say. Unfortunately, this time, I'm limited in what I can say without express permission. So the statement that seems like opinion could be understood to be conveying the hidden facts known only to Magnus Carlsen, defamation by implication. What statements of fact would those be? Well, this is a letter to the chess world, so it would be the facts known or understood to be conveyed by the chess world, namely that Niemann might have had some sort of intimate personal device that was in or about his person conveying the chess moves. So defamation by implication is definitely something the court and jury might be looking at in this case.
So basically the way we apply the analysis here to Magnus particular, the claim against him is Magnus has come out and said that he has more evidence, that he cannot release that evidence without Hans's permission. But that begs the question, what if he doesn't actually have more evidence? And he was just saying that basically to imply that Hans is a cheater. If that is the situation, that is more than just an opinion. You are implying that Hans is a cheater, and if he didn't have more evidence, he would have known that he didn't have no evidence, so he made the statement knowing it was false. And because the statement was written and not spoken, it would be libel, not slander, even though those are both part of defamation. So even if Hans is a limited purpose public figure, there might be enough to successfully sue Magnus. It's just going to depend on what information they obtain during discovery. For instance, here's some statements that Hans is alleging were defamatory that were made by Hikaru. This is something that's been going on for a long time. I've heard it from many different people, and when Magnus is a world champion, essentially I think he's saying there's something weird going on. You have to start and look at it a bit differently. Why would Magnus say this if there's literally no hard proof? Like I said, amongst grandmasters, this rumor has been around forever. The problem with this is if Hans is a limited purpose public figure, he's going to need to prove that Hikaru knew that these statements were false. So it doesn't matter what he thought. If other grandmasters, if this was a rumor going around in the chess community, then Hikaru is not getting to that standard that you need for malice. Additionally, a statement like, why would Magnus say this if there's literally no hard proof? If Hikaru doesn't know, let's just say Magnus did make this statement with no hard proof, that's defamation on Magnus, not Hikaru. So in conclusion, I think Hikaru is probably completely clear of any defamation claims outside the existence of some smoking gun evidence like a text message thread or an email thread between him and Magnus basically saying, LOL, let's ruin this guy's career. He totally didn't cheat, but let's make everybody believe he did. That's the kind of shit that we would need. Now let's talk about chess.com and Danny Reich. So according to the petition, just days later, chess.com and Reich piled their own false accusations regarding Niemann's play. These false accusations were specifically designed to depict Niemann as a serial cheater and thus reinforce Carlsen's accusations that Niemann cheated against him over the board. Specifically on September 8th at 6:58 p.m., Reich caused chess.com's Twitter account to post the following statement. Dear chess community, we have shared detailed evidence with him concerning our decision, including information that contradicts his statements regarding the amount of seriousness of his cheating on chess.com. So let me give you all the highlights of the chess.com report. Basically, what it said was that they analyzed a whole bunch of different games with Hans, and statistically, he plays the highest perfect percentage out of any other chess player. And while they cannot confirm that he was cheating while he was playing these games, it is just very fishy that somebody would play that good of chess. He was playing chess so good that the only logical explanation is that he was using a machine, or at least that's their argument. Now, the counter to that is Hans is projecting himself, portraying himself as a chess prodigy. And what is a young chess prodigy going to do? They're going to play really good chess games, and they're going to get better all the time. Another issue with the chess.com report is basically saying Hans has such a rapid rise in his elo that it has never been seen in the history of chess. He's getting better, faster than anyone in history. And Hans's retort to that is going to be, hell yeah, I am, because I'm a chess prodigy. So basically, Hans's position is going to be, yeah, chess.com, you basically said all of these things and you implied that I'm a cheater, but you don't have any proof. You're just showing the results and saying I cheated rather than showing proof that I cheated. And if that's the case, then maybe you could make the argument that they made these statements without having hard proof, and at the very least, they implied that he was a cheater. Or they definitely implied he was a cheater, but you get the point. Okay, so I just basically just put maybes for the libel section. Oh my God, I've been making this video for so long. I actually have to go to work, y'all. Everybody just wanted to hear about the defamation. Here's how I think the defamation is going to play out. I'm sorry I couldn't analyze Play Magnus. If you guys want more information about the antitrust, tortious interference with contracts, civil conspiracy, money damages, maybe I can make a part 2. Let me know if you're interested in this, but I think most people were just interested in the viability of these claims. And at first blush, if they can get over the jurisdictional issues, there's probably viability, depending on what comes out in discovery. For a majority of the parties, I think Hikaru, of all people, is probably going to get dismissed for sure. Not for sure. No lawyer can ever say that, but you get the point. All right. Talk to you later. Bye.
He's a catastrophic injury attorney who accidentally became a YouTuber. Attorney Talk.